This is Ira Gorlick, and this discussion is on telecommunications in the commons. So there exists a thing called the commons, and we talk about maybe public property or public rights of way. I call it the commons, and I should probably put that in quotes. Um, and let me give you an example using homeowners associations and condo associations as an example of the commons. Often, joining these associations are mandatory to live in that community, and also mandatory are the monthly or annual payments to the homeowners association for upkeep of the common areas. In the condos and homeowners association I belong to, they were mandatory. If you lived in the neighborhood, you had to belong to the homeowners association and you had to pay the dues. Again, this is a picture of the clubhouse in our subdivision, which is managed for the common good. From my perspective, and this is important, I'd be interested to know what you think, this is the same as taxes to live in a city or a state. I choose to live in this community, and so I pay the homeowner's fee. I choose to live in the city that I live in, and I pay the taxes. I choose to live in the state that I live in, and so I pay those taxes. If I didn't want to pay these homeowners' fees or the city taxes or the county taxes or the state taxes or the federal taxes, I can move. Even though an individual may own their own house or condo, everyone in the HOA must be equally responsible for maintaining the common areas, such as landscaping, swimming pools, clubhouses, sidewalks, security gates, roofing, and building exteriors. So you see what I'm saying here, and this goes to the whole idea of private and public property, is that there is a precedent for individuals to choose to belong to a community where they share a common goal and common expenses. HOA fees help maintain the quality of life for the community's residents and protect property values for all owners. In addition to maintaining common areas, HOAs also set out certain rules that all residents must follow called covenants, conditions, and restrictions. In a common building, rules may include what color front door you may have, whether you are allowed to line dry your laundry outside, whether you can have a satellite dish, the size and types of pets permitted, and so on. In many ways, these rules are similar to the types of rules cities and states enact or communities enact. And I think that's important for us to understand the economic principle operating here. So I've talked about rights of way, and I've talked about how that's an important economic concept. And so let me just go a little bit more as to rights of way as an example of commons. The term right of way means a way over which the public have a right to pass. And I showed a picture of a street here. Before coming into force of the Highway Act in 1835 in the UK, there were no public rights of way which were not highways, and all highways were considered to be maintainable by the inhabitants at large in the parish. In other words, and there are many people, by the way, who think it's the way it should be now, is that there are no such things as public right-of-ways. However, the common law position was that inhabitants of a parish were bound to repair the highways unless it could be shown that the responsibility for repair had attached instead to an individual or corporate body by reason of tenure, enclosure, or prescription. As long ago as the Stone Age, trackways were built to enable communities to trade with one another, and by 43 AD, when the Romans began their conquest of the Celtic Britain, some long-distance trade routes had been created. Many public rights-of-way were created between 1750 and 1850. And this goes back to my last one about community taking. So somebody owned that land before, and now the community came in and says, we are going to take that land for a road. During this process, new legal rights to cross the land were also created. These included both public rights of way, highways, and private rights of way. Let me use some other examples. The common pool terminology usually is applied to a natural resource such as a fishery, but it also can describe many goods and services that are freely provided. A good example is a shopping mall parking, and I have an example of a shopping mall parking there. All the tenants of the mall pay for the parking lot so that the lot becomes a common good. and all shoppers have free and common access to a scarce good or resource that is subject to rivalry and consumption because one's individual use diminishes the benefits that another user gains. So now you see why I talked about rivalrous and excludability. Previously, we talked about public and private goods. This diminution often involves crowding, congestion, and a deterioration of quality for the users as a result of overuse. This is the tragedy of the commons. So here's another example where I talk about the tragedy of the commons, of course, and it arises as a negative externality. No user is fully liable for the cost of his or her use. Crowding and rapid quality problems occur when this resource is overused. This is where there is an economic question for telecommunication. Others we've talked about, for example, monopolies and rights-of-ways. Is telecommunications a totally private good or a partly common good? Wired phones need rights-of-way to lay cable. Are those rights-of-way common or private? Wireless phones, satellites, and broadcasters use electromagnetic spectrum. Is that spectrum common or private? And in fact, this is probably the rights-of-way and the electromagnetic spectrum are the key understandings for telecommunications law from an economic perspective. Is that are they common or are they private? Are they part of the public domain or are they private? And by the way, that's not a binary. They could be common, but then they could be managed by private, as I talked about earlier in the lectures. I suspect your political, religious, or economic biases will affect the way you answer that question, which is why in the discussions I think this is going to be very important. So let me give you an example of how this all applies. There was a case in 1916 called Essex versus New England Tel. And there was a thing in 1866 called the Post Road Act. And let me read what it says. The Post Road Act of 1866 substantially declares, in the interest of commerce and the convenient transmission of intelligence from place to place by the government of the United States and its citizens, that the erection of telephone lines shall, so far as state interference concerned, be free to all who will submit to the conditions imposed. In other words, they're saying the right-of-way, the telegraph lines. Remember I showed a picture earlier of all the telephone lines on that poles. And remember how crowded it was getting. And the cities were trying to put in restrictions as to how many on those roads, on those poles, that this law, this court case is saying that the telegraph lines are free to everybody and that the community cannot benefit one or the other. To me, this is exactly what's going on in net neutrality. So remember in the technology section, I've talked about the Stroger switch being an early example of net neutrality discussion. Well, here's one in 1916 that has a similar sort of approach in terms of net neutrality and who can control this medium, this technology. And here's further saying a city may not arbitrarily exclude wires and poles on a telegraph company from its streets, but may impose reasonable restrictions and regulations. So therein lies the key. And this is where your bias, and it's important for us to have the discussion, is a free marketer or libertarian going to say that may impose any restrictions or regulations or impose reasonable restrictions and regulations? And I think this is critical. And by the way, I may want to go and explore that right there in that sentence, but may impose reasonable restrictions and regulations. Is that different than saying may impose any restrictions and regulations? Where a town has given written permission to a telegraph company specifying how posts could be placed and wires run, and the company has complied with such permission, such lines are protected by the Post Road Act of 1866, against subsequent exclusion or other arbitrary action by the town. Arbitrary action by the town. This is just great. This actually, I'm going to explore this more because I think this is critical to the overall approach to this class. So the next lecture, I'm going to end this series on the idea of rent seeking. I'm hoping you're enjoying these lectures so far. I'm certainly enjoying putting them on. Thank you.